Hey everyone, this is Ray and Jay. We're with Agency A to Z. We actually have Miss Carol here, who's been a paralegal for a while. She's helping us with our estate and will planning. Miss Carol, give yourself a quick introduction, if you wouldn't mind.
Yeah, sure. I've been a paralegal for over 30 years. Dealt a lot with civil litigation for a while, and then decided to go over to estate planning, where I get to help people a little bit more than suing people. So it's very beneficial. I enjoy it a great deal. So I do with some attorneys writing them. I do some trusts and wills and deeds and a lot of different estate planning documents.
Awesome, awesome. Well, we wanted to speak specifically to you today about uh, a life estate. You mentioned it
Mhm.
before, and it's really for what we call our blended families. Can you speak a little bit about what a life estate trust is, or special need,
Sure.
not special need, life estate is?
Yeah. Life estate is basically an amendment to your current trust. If you have a trust and you want to allow somebody to live in your home after you pass, making sure that none of the beneficiaries or the successor trustees sell the house or kick them out or anything like that, it's an amendment you can do to your trust. And if you have a trust, if you don't, a trust is a good thing to have. Basically, what it does is, for example, we'll use an example of a second marriage, and one of the spouses owns the property, but the other spouse does not. But they live there together, and that one that owns it, if anything happens to them, they want their spouse to be able to stay in the house and live there for as long as they want. So we write what's called the life estate amendment to the trust, and that basically says that this person is allowed to live there for until they die or until they permanently move out of the house. And the reason we say it that way is in case if they had to go to an assisted living place or something like that, then that means they've permanently left the house, and the successor trustee can then follow whatever instructions that the initial trustee told them to do. So they could say things like the person has to maintain the mortgage or definitely maintain the property and pay the utilities and what have you, or they can allow that if the trust has enough money, they can allow the trust to pay that expense. It is entirely up to that initial trustee on how they want to write it. So if sometime during that person's lifetime that owns the house, they change their mind, they get divorced, whatever, they can amend it and change it back. They can do whatever you want because a trust is a revocable trust, this one that we're talking about, and can be changed during the lifetime of the initial trustee. After they pass, the successor trustee takes over to do everything that they've asked for in the trust, but they can't change anything. It becomes irrevocable.
Understood. And you just made me think a little bit because obviously, we do have a lot of blended families out here,
Hmm.
and a lot of times that new spouse doesn't necessarily all the time get along with the children, and
Yeah,
to leave the children in control
yeah,
could be a little bit tricky,
yeah.
would you say? Yeah.
And
So,
that's,
go ahead.
I'm sorry, that's exactly what this clause is for, just
Hmm.
to protect the other spouse
Yeah.
from anybody trying to do anything.
Yeah, that would be kind of I'm getting actually a chill because I can think of scenarios where that would potentially happen. And if the spouse doesn't care too much or doesn't protect themselves, something like that could potentially happen. And I'm sure in your experience, are you familiar with anything like that? Oops, looks
I'm
like we.
sorry. Can you repeat that
Oh, there you
again?
go. So yeah, I was
Yeah.
saying just because you've been in the business for so long, I'm sure you've seen good and bad stuff on that scenario. So have you ever
Oh yeah.
experienced a scenario like that? Can you tell us a little bit more about it? Where basically
Oh
the
yeah. Oh
spouse
yeah.
might have been left on the hook.
Yeah. People have gone into, as I said, my litigation side. There's things like trust litigation where the beneficiaries will try to fight what they're saying and not allow that person in the house and staying in the house, and even though the trust says so. They ultimately lose, but that is because it's what the trust wants and what they dictated and what the initial trustee signed for. So to your question, yes, I've come across that, and the protection in the trust is what gives it to them. A lot of times you'll have a trust, but you won't have that clause, and the successor trustee will try to sell the house to pay everybody off or what have you.
Wow. Wow. So when
Yeah,
most people think about,
it can get messy.
yeah, and
Yeah.
relationships change. Relationships change, and when definitely there's money on the
Hmm.
table, they might feel a certain way, especially, if they don't get along, with the blended family.
Right.
So another question that we always come up with is trusts are only for the rich people. I know it's getting more popular nowadays, somewhat. What would you say to trusts being only for the rich people?
I say absolutely not. It's for anybody that wants to protect their property, what they own, their legacy, their business. You can put a business in a trust, even if it's like an LLC. You can transfer the interest of a business, and the trust is a huge difference than to probate. So, for example, if you had a property and it had a trust, but for some reason you didn't put your property in the trust, it has to go to probate. Now, probate
Mhm,
can take, depending on the state, 6 months up to 2 years. There's a whole process. You have to get an attorney, you have to go to court, you have to get approved
mhm,
by the court to be the person that takes care of everything. And then you have to get
mhm,
step by step approvals for everything you do until the court says okay. So now your attorney's getting money out of this. You're paying filing fees to the court. You're paying publishing fees. There's a lot of fees involved in probate, and so you go through all that just for them to say, okay, either you can put the property in the trust, or you can sell the property, or you can do whatever you want. When you have a
mhm,
trust, that authority of the next person you've nominated becomes immediate, and they don't need anybody's
mhm.
approval, and they can do anything they want that you've said in the trust on day one. So they
Got it.
can take over and make it seamless. The other thing is when you have a probate, your will is what's called lodged with the court, meaning filed with the court. And anything in that probate, including the will, becomes public. When you have
Mhm,
a trust, the trust is not recorded anywhere. So you have a private trust that nobody knows your intentions and what you want to do, unless you give somebody a copy of that trust. So
mhm.
that helps too. And you can name your trust anything you want, so people don't necessarily have to find it. I mean, when you put your property in there, it's going to be owned by the trust, and that's what it's going to say. Now, your deed to your property is public, but it'll say it's
Mhm.
owned by XYZ Trust, and nobody knows who that is because the trust is not recorded. So it's a little bit of a privacy matter too that helps.
Exactly. And there's a few things that popped up in there, but we'll handle that on a different talk. But let's go revisit the life estate again. So
Hmm.
for blended families, that may or may not, even if wouldn't you say even if they have a great relationship, they still would want to have some protections in place just in
Oh,
case, because you don't know how
absolutely.
to.
Yeah, it's nothing personal. It's just
Nothing personal.
it's nothing personal. It's just what they're doing to protect their own assets.
And protect.
No matter how small they are, and it doesn't even have to be property. They could have bank accounts that they don't want to have distributed right away because they'll have beneficiaries on them. So anything that you want to have in the trust, you make the trust the beneficiary. So if
Got it.
you can make life insurance the trust beneficiary, you can make your bank accounts the trust as a beneficiary. So it automatically gets transferred over there. And then you have the money in the trust to access.
Mhm.
Many times, though, when you have a trust, you have a trust bank account. So your money is already in that account anyway, and you're signing those checks like as just your same name, but just with the title of trustee after it.
Interesting, interesting. Well, we're definitely gonna pick your brain more about that in another video. Jay, do you have anything else to close
Uh,
out?
Once again, Carol is like God sent, man. She is awesome sauce here. We love working with her at Agency A to Z. And I always say in my meetings, when we deal with blended families, it's such a touchy topic, right? How do you tell your spouse that you don't want their kid to have this, or how do you tell, your husband that you don't want his daughter to have this, right? And I always say, just tell them, right?
Hmm.
Just okay. Let's talk about it and let's put it in here. And the ability to put in that life estate that protects your loved one just in case kids want to come after it. I mean, there are horror stories of kids that are estranged from their family members coming after their stuff because they heard that their mom or dad passed, right? Protect it using the trust. And if you work through us, you can see how you can get, these trusts at a discounted cost and you actually control the software. So thanks again,
Awesome.
Carol. We really
My
appreciate
pleasure.
All
it.
right. So Ray, Jay, and Carol from Agency A to Z. Have a good rest of your day.
You too. Thank you.